going to start the recording. So let me begin by welcoming you to our final tutorial session, and I also wish to congratulate you for making it this far. I know that it's not easy trying to complete a unit because there are always a lot of demands that get in the way. It could be about work requirements, it could be family issues, and it could be all sorts of things. And it could be the workload alone from having to study a lot of units in a loss program. And so I strongly commend you that you've made it this far, and I have no doubt that most of you or all of you will end up finishing administrative law successfully. So well done. So before we talk about access to information, would you happen to have any questions that you may want to raise? Comments? And I wish to issue a reminder or an appeal that if you haven't had a chance to do the survey, perhaps you could do it after this last tutorial. Because I had that email from the Deputy Dean for Teaching and Learning, again, making a reminder, asking me to remind the students that we need at least 50% of the cohort to actually do the Have Your Say survey. And his email actually follows the emails to him as well, instructions perhaps from the Deputy Vice Chancellor for Academic Affairs, that we really need to have a high level of survey responses from students in order for us to be able to make improvements in the delivery of the unit. So at the end of the day, any survey responses you make will actually be for the better of the next cohort of students who will be taking up this unit, because then we can make some adjustments. We know what could have been improved and so on. So after the tutorial, I'm hoping that you will take the time to do that. Okay. Any questions, comments before we talk about access to information? So we're good. Okay, so we've saved this for last because that's the way it has been treated in the prescribed textbook. But in a sense, it also provides us an opportunity to remember what administrative law is all about. And administrative law mainly is about providing opportunities to police the exercise by the executive of its powers. And one way by which the exercise of the powers of the executive, which to a great extent are coercive, because they're coercive because when the executive makes decisions, they often affect our lives. It could be decisions about licenses, decisions about marriage and so on, decisions about benefits and so on. So they impact us. And if there is no way to control or police the exercise of executive powers, then you can just imagine how difficult it can be for the citizens, where there is no opportunity for them to have decisions which interfere with their rights or their interests or legitimate expectations or their obligations and duties, if there is no avenue for them for redress. So ultimately, therefore, it's a way of policing the executive and making sure that the executive is accountable for its activities. Now, there's another way by which we can say that the activities, decisions, or actions of the executive can actually be controlled and held to public account. And that is by ensuring that the public has access to information. Because if the public is unaware of what's going on, a lot of decisions are actually made behind closed doors, or documents cannot be accessed by the public. And it could be about the executive spending public money without any sense of accountability. They could be doing it for personal trips, paying it for mistresses and so on. It could be throwing lavish parties or going to restaurants and spending so much money without an opportunity for us to examine these documents and having access to information. There would be very limited scope for the public actually to take action to ensure that the executive is held to account for their obligations to the public. And that is why access to information is very important in a democracy. Those places where you might say that access to information is important are typically those places where the governments are authoritarian, and they would rather that people be ignorant of what is going on. But as they say, information is power, or knowledge is power. So with knowledge, with the acquisition of knowledge, then people are in a better position to make decisions. Not only directly to make the executive, have to justify making certain decisions, but at the same time to enable the citizenry to make decisions on the basis of the ballot box. So that's how important it is. So tonight, after studying this topic, you should be able to discuss and explain the importance of freedom of information legislation, key principles of the Freedom of Information Act of 1982, the legal right of access under the FOI Act, and exemptions, conditional exemptions, and public interest factors under the FOI Act. There will be two conceptual questions where we begin to discuss the FOI, Freedom of Information, and then I will end up with three discussion questions or tutorial problems, one of which will indirectly address the final quiz, which relates to freedom of information. So let's begin by looking at discussion question 1. What does the Freedom of Information Act 1982 play in administrative law?
Promotes the transparency of government.
Mm-hmm. How is that, Monique?
I guess if a decision is made in relation to your own circumstances and another party has put forward documents that were relied upon, then you might seek to view those so you understand how the decision was made.
Very good. Very good. Okay. Thank you. What do the others say? What role does the Freedom of Information Act play in administrative law? What do the others say? The role of the Freedom of Information Act and its object, it is crucial that we grasp that role or its importance, because that actually plays into decisions made with the courts and even by the Information Commissioner later on when there is a request for information. So the courts, the Administrative Appeals Tribunal, when it reviews decisions of the Information Commissioner or the Information Commissioner himself, when they make decisions, they do so with the understanding that freedom of information plays an important role in administrative law. So they don't make decisions about access to information divorced from a knowledge of the importance of freedom of information in administrative law. What do the others say? So on the one hand, as pointed out by Monique, it gives the citizens an opportunity to ask the executive or the government. So it's not actually just the executive, but the government in general. So in other words, it can include the judiciary to an extent, which we're going to get into in a short while, to provide information, especially in those instances when a citizen may ask or an interested person may ask for certain documents. So that's kind of a very reactive approach. But there is a proactive approach in the sense that the Freedom of Information Act and guidelines that have since been issued by the Information Commissioner actually encourage government agencies to bring out into the public domain certain important documents so that it becomes unnecessary already for individuals to gain access to them. So there is that other aspect. And the other critical role of the Freedom of Information Act has really been to give citizens an opportunity to have some of their personal information amended or corrected. So as we know, the government holds a lot of personal information about us. So the government has a database about that. It could be, in terms of personal information about health stored in Centrelink records. It could be employment, It could be, marital status and so on. And oftentimes, a lot of these information may already have been outdated. Some of them may actually be incorrect because they were incorrectly entered into the system by some clerk. And oftentimes, we need to be aware that the personal information that is out there that can be potentially be available to a lot of other people, it could be government agencies, it could be employers, and so on, may actually not be to our interest unless they are actually properly corrected. So the freedom of information provides that opportunity for individuals to be able to have personal information that would be incorrect or incomplete or misleading or out of date to be corrected. Okay, and as Peter said, the freedom of information certainly promotes openness of government, especially because imagine from the viewpoint of decision makers, if they are aware that whatever they do can be subject to public scrutiny because individuals can then examine the documents that they have, then they would be more conscious of making sure that everything they do is according to the law. And everything that they do would be something that would be acceptable to the public, who are ultimately the people that they are accountable to. Okay, so let's go to the second discussion question. What are some of the conflicting themes in having a freedom of information legislation?
Privacy.
Okay, can you explain that, Monique?
So obviously the person considering the release of information or a document under an FOI request would have to consider whether or not it breaches anyone's privacy.
That's right. So you wouldn't. So on the one hand, while we want freedom of information, you wouldn't want just anyone to be able to access personal information, your personal information. That would be very disturbing if people could just request information about you that is stored in government records. So the freedom of information acknowledges that there are constraints around that, so that personal information cannot be the subject to, especially under the Privacy Act of 1988, personal health information or personal information about an individual cannot be divulged without the consent of an individual, even if the individual is deceased. So there is that conflicting theme. How about in terms of security, Leonie? How is that? How do you explain that?
I would say that governments don't want certain secrets being released under freedom of information because of national security risks or
that's right,
government policy or how things work.
That's right. That's true. So I like the picture of the dog there. That is true. So under the Freedom of Information Act, certain government agencies are actually exempt from the application of the Freedom of Information Act. In particular, for example, the ASIO, or the Australian Security Intelligence Organization. They are not subject to the Freedom of Information Act, because imagine if the ASIO and the federal police can be required to provide documents or records that they may have pertaining to certain operational and security related activities. That would then that can then be used by terrorists or criminal enterprises to go around certain laws and in order to be able to do and undertake certain criminal activities with impunity. So that is one exemption. So on the one hand, you want to be able to provide information, but at the same time, you want to be able to limit the access by the public of information, especially if it may have an effect on security. How about in relation to inhibiting freedom of discussion, as Peter said? How does it work? How does this work, Peter?
Well, if you're having a free and open, frank discussion about perhaps a policy that has been put forward, it can blur the lines if everything about that particular discussion comes out into the open. it can create fuss where there's, mountains out of molehills.
That's right. So the problem with freedom of information and the knowledge that any individual can actually just seek access to certain documents, including deliberations made by government officials, can actually discourage frankness and candor in the discussion of these very sensitive issues, because the decision makers may just decide to play it safe because they don't want to be caught on the record about making inappropriate comments or inappropriate recommendations and so on. And so therefore, if decision makers are very fearful about anything that they say, because it can then be brought out into the open and be used against them, then certainly that will inhibit the discussion that will be crucial in a lot of deliberations made by government agencies. So as we will later on know, deliberative matters by government agencies is actually an example of the documents that emanate from those deliberative discussions are actually conditionally exempt. So the person who is in possession of those documents can consider whether it is in the public interest to release these documents that pertain to deliberative matters. And if the person believes that the disclosure of deliberative matters would not be to the best interest of the organization, then they can decide not to release these documents. So there is that other aspect as well. And as Peter pointed out, there's always the danger that a lot of these documents, not only do they pertain to security, but it could also be about international relations. And if the release of these documents pertaining to international relations can harm the relations with other states, then again, that is one instance when the Freedom of Information Act provides an instance when certain documents should not be made accessible to the public. Okay, any questions so far before we start talking about particular discussion questions? So we're good? Okay then. Can I have somebody read discussion question 3?
I'll do it. Troublesome Eddie, a quarrelsome person, asked the Parliamentary Budget Office, the PBO, of the Australian House of Parliament to provide documents and receipts under the Freedom of Information Act 1982 Commonwealth relating to the treatment of the back pain problems of former Prime Minister Kevin Rudd, which might have included visits to a masseuse while he was a Member of Parliament. The PBO refused to submit such documents and receipts in line with the Privacy Act 1988, and on the ground that Troublesome Eddie has no legal standing and no legitimate purpose for making his request. What legal advice would you give Troublesome Eddie?
Thank you. So what legal advice would we give him? This came out in the news, I think, 2 or 3 years ago, when in the newspapers where there were reports that Kevin Rudd had used government funds to go to, a masseuse and have some kind of massages for his back pains. And that was upsetting to a lot of people why, government funds were being used for those treatments. And I understand that there were people who may have, certainly he could have afforded it. So.
Excuse me, Manjo. This is a question related to this discussion question, but also to the quiz. Now here it says that Eddie asked the Parliamentary Budget Office to provide documents and receipts under the Freedom of Information Act. Now, are we to assume that he asked them in writing or not? Is that not an assumption that we should make? Because I wanted to clarify that with the quiz question as well.
Okay, so my answer there is let's not focus on the manner by which the request was made.
Okay.
We're kind of focusing on whether there is a valid ground for him to be denied access to the
sure.
basis of the process, but really on the kind of documents that were government.
Okay, thanks. And is that the same approach to take with the quiz then?
Yes.
Okay, Ta.
What do you think?
Banjo, I'm going to play the devil's advocate here
Mm-hmm.
and say that I think that he has a legal standing
Okay.
because if the bills were paid out of the public purse,
Okay.
you know, we all have a legal standing to know.
Okay.
However, if it was paid privately, no, he's got no standing whatsoever.
Let's talk about legal standing. Is it necessary for anyone who wants access to certain documents held by government agencies or prescribed authority, as you find under the Act, to show that they have legal standing or that certain documents may actually have an effect on them? Is that important?
He does have to have an interest in it.
Is that a requirement? So what if somebody is interested to get documents simply because he's curious, or actually he wants to cause trouble?
They don't have to give a reason.
Okay, very good. Very good. Leonie, what do you say?
I was just thinking that everyone's got a legally enforceable right under Section 11 of that Freedom of Information Act to access.
That's right. So it doesn't matter who's asking it. So everybody, that's the entire purpose of the Freedom of Information Act. It is to provide all persons in the Australian community access to government documents, whatever they, you know, they are not required even to provide any reason. If they want to do it for curiosity, it is their right. It is their right under the Freedom of Information Act. So the fact alone that, you know, somebody is actually there to perhaps embarrass the government, again, is an irrelevant factor in determining whether or not that person should be denied access to certain documents in the possession of government agencies or prescribed authorities. So going back to that point of PETA, because yeah, go ahead.
Can I just add something to that?
Go ahead, yes.
Unless it was paid out of the public purse anyway, it wouldn't have anything to do with the Parliamentary Budget Office.
Ah, right. Now let's assume that, you know, public money wasn't used, but somehow, you know, they're required to provide reports, whatever. And so it's in the, you know, it's probably in the records there somewhere. Would it mean, therefore, that before the Parliamentary Budget Office makes a determination to release the records, it will have to decide whether or not public money was used for the treatment? So is that a factor that should be considered, or is it sufficient that the documents are in the possession of the Parliamentary Budget Office and somebody has requested for it? Or must they go behind such that you know, they couldn't be provided access? Leonie, I may have missed this. Is the PBO an exempt agency under the Freedom of Information Act?
Oh, I'm just going on by what's in the notes, Manjo. It said that it was a condition, an exempt agency under Section 7.
Did I say it here?
Yeah, these are blah, 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 and then the last two are Parliamentary Budget Office.
Okay, very good. So I may have...
Sorry, I'm trying to get a kid.
Okay, then. So let's assume that, so that takes care of it. It's so in other words, if it is an exempt agency which is there, and I missed that, wow, okay. Fantastic for pointing that out to me. So let's assume that it's not the Parliamentary Budget Office, but some other, thanks, Leonie. So these, you know, when it comes to the specification of exempt agencies, it often can be difficult to remember them all. So thanks for pointing that out to me. Yeah. So let's assume that he's not the Parliamentary Budget Office. This is a good thing I didn't ask this in a final exam question. It would have been embarrassing. So thanks for that. Now, so let's assume that it is in the possession of a government agency that is not among those considered to be exempt from the application of the Freedom of Information Act. So the focus of the question then is whether or not these records or documents can actually be accessed by the public. What does yes mean, Monique?
I would say that if it's not an exempt agency, that yes, he has grounds to request the documents and they could be released. But, you know, they may go through lots of redacting and removal of information anyway, that there might not be much left on them. So he could still ask for them, I think.
Okay. So that's right. So on the one hand, you know, there's that balancing act between ensuring that the public has access to certain documents, but on the other hand, there is a requirement that it must not be about personal information of an individual. The question is, does this relate to personal information that should be held in confidence? Does that relate to personal information about Kevin Rudd? Or would the documents pertaining to receipts concerning the treatment of the back pain problems of Kevin Rudd, would they relate to personal information or health information about an individual that therefore would not be accessible both under the Privacy Act of 1988 as well as under the Freedom of Information Act as well?
Yeah, Manjo, it's Gay. I put in the chat yes, but now I'm starting to think no, because looking at the Act in Section 11, it says an official document of a minister. So you wouldn't think that his masseuse receipt would be an official document. I don't know. That's
right. So in this particular instance, the correct answer would be that Troublesome Eddie, regardless of his purpose for wanting to get the documents, actually has a right to access these documents, and that these documents do not relate to personal information about Kevin Rudd, and so they are not documents that are conditionally exempt from the application of the Freedom of Information Act. And they're also not documents and receipts that are protected under the Privacy Act as being available to the public for access. So for these reasons, the legal advice I could give to Troublesome Eddie would be that he indeed has the power under the Freedom of Information Act of 1982 Commonwealth to seek access to the documents pertaining to the receipts, the documents and receipts pertaining to the back pain problems of Prime Minister Kevin Rudd. Okay. Now let's go to question 4, and now this one is the one that is very pertinent to the final quiz that we have. Can somebody read that particular question for us?
I'll do it, Major.
Thank you, Rob.
Olaf Adams, a self-represented litigant and father of Monica, was very upset after the court registrar issued an interim order awarding custody over a 6-year-old Colette to the mother at a family court hearing of the Federal Circuit Court, the court, on the 20th of November 2017 into the matter of child custody. The court registrar issued the order based on the family report issued by a court-appointed family report writer. The registrar, citing confidentiality, had denied Adams' request for a copy of the family report. Olaf has come to you, a solicitor, for advice. He wants to know if he can use the Freedom of Information Act 1982 Commonwealth to compel the disclosure to him of the family report. Assume the court registrar can lawfully issue the court order. What advice would you give him?
Thank you. Thank you, Rob.
can I just clarify that Olaf is the father of Monica and Colette? Is that right?
I should have changed the name. Sorry. And father of Colette. Sorry. There.
Thanks.
They're one and the same.
Okay.
So they're one and the same. What advice would you give Olaf? So maybe the first question we have is, are the federal courts not covered by the Freedom of Information Act? Or does the Freedom of Information Act apply to them to an extent? So very good. So the Freedom of Information Act, in fact, applies to the federal courts. Very good. Now the question is, this particular document, which relates to the family report, is that a document that could be released and subject, therefore, to the Freedom of Information Act? Okay, very good. So, well, you've got it correctly. The answer is no. So under Section 5 of the Freedom of Information Act, the Act does not apply to any request for access to a document of the court unless the document relates to matters of an administrative nature. And the High Court has already ruled on what, well, in a sense, it's actually an obiter dictum, but in the case of Klein versus Official Secretary of the Governor General, the court had an occasion to explain what documents actually are considered to be to relate to matters of an administrative nature. And these would typically relate to those that would be about the management or the administration of certain office resources. It could be about those that provide logistical support for the exercise of the substantive powers or functions of the court. But if therefore those documents pertain to the exercise of substantive powers of the court themselves, then in that case, the court itself, then in that case, it cannot be said that that document is of an administrative nature. So in this particular case, the family report would obviously be one that is closely related to the substantive power or function of the court, particularly in relation to child custody. And in fact, as you notice, it is linked to the interim order. So you have two problems there. One is following the Freedom of Information Act. It is very clear in Section 5 that the Act would not apply to any request for access to a document that does not relate to matters of an administrative nature. So it is only when a document relates to a matter of an administrative nature that there can be access under Section 5 of the Freedom of Information Act. But secondly, the other thing we have to consider is that this is a decision of the court. I mean, it is part of a decision made by by the registrar acting in behalf of the judge. So that the bigger question is if a decision has been made by the court registrar not to release the family report, then for the parliament to interfere with the exercise of the substantive powers of the court may mean an interference with the separation of powers. It's practically the parliament saying, what courts can or cannot do, and courts certainly won't allow that. So you've got dual problems there. So from the viewpoint of constitutional law, it is unlikely for the parliament to be able to pass legislation that would tell the courts what they should be doing, or what documents that they could release and make available to the public. But at the same time, aware of what the courts are likely to allow, the Section 5 of the Freedom of Information Act has been quite clear that it is only in relation to documents that relate to matters of an administrative nature held by a court that can be the subject to a request for access by the public. So in this case, if Olaf had come to you for advice, your advice should be that he has no recourse. He cannot have access to the family report under the Freedom of Information Act, because the family report is not a document that relates to a matter of an administrative nature. It has nothing to do with the management or administration of the court. And neither does it have to do with the provision of logistical support to the courts. But in fact, the family report is closely linked to the exercise of the substantive powers or functions of the court, and therefore are beyond the coverage of the Freedom of Information Act of 1982.
Manjo, can I just seek some clarification? I'm finding it hard to put this into words, but is a way that you can sort of test whether something might be suitable for release, that just because it involves him and he's the one asking for, or does it involve him, or have I assumed that?
It involves him.
Yeah. So just because it involves him and he's asking for it doesn't automatically mean that he's entitled to that information, because under the Freedom of Information Act, it could be released to anyone if it was something that was able to be released. So just because you have personal details in there doesn't entitle you to that information. Is that right?
That's right.
Okay, thanks.
To a great extent, it's almost irrelevant that Olaf Adams happens to be, somebody who is closely connected to the case before the court. It's actually irrelevant, because if the court document is actually one that relates to an administrative matter, it could actually be anyone that who could ask for access to a court document. But the context we have here in the facts is that it can happen. It can often be the case that a party to a court proceeding is not given an opportunity by the court to actually access certain documents, certainly for confidentiality reasons, or those where there might be questions about domestic violence. And in those cases, there are certain documents and reports that are not given to the other party, and that's a decision made by the court. And so the question then is, can the Freedom of Information Act be used as as the instrument to compel the court to release certain documents? That becomes the bigger question, and the answer is no, for two reasons. So one is the Section 5 of the Freedom of Information Act is very clear that it can only be in relation to documents that relate to administrative matters that can be the subject of access or a request for access under the Freedom of Information Act. But those documents which relate to the exercise of the substantive powers or functions of the court certainly cannot be the subject of the Freedom of Information Act of 1982. But at the same time, following the principle of separation of powers under constitutional law, the courts would not tolerate the Commonwealth Parliament passing legislation that would tell the courts what it can or cannot release in terms of documents, because that would interfere with the integrity and the independence of the courts, and it would also impair the separation of powers in Australia. Okay, questions? Very good. So at least you have an idea now how to answer the final question, and I'm hoping that more of you will end up getting the that particular quiz question correctly. Okay, so final question. Can somebody read that particular question for us?
I'll do
I'll
it.
read it.
Oh, do you want to do it? Jane Anwar, a PhD student of Griffith University, was doing research on sexual harassment at universities and had heard about a confidential report to the Australian National University Council relating to sexual harassment in the ANU. Citing the Freedom of Information Act 1982, she sent a request to the ANU Council Secretary for a copy of the confidential report and the minutes of the council deliberations that led to a decision not to release the report to the public. Brendan Smith, the ANU Council Secretary, replied later, rejecting Jane's request for the two documents. He said that the ANU is not covered by the Freedom of Information Act, since it is not an agency of the Commonwealth but was created under the Australian National University Act 1946. Brendan further stated that even assuming that the ANU were covered by the Act, the two documents were documents exempt from public access under the Freedom of Information Act. In any event, there are no written minutes of the University Council's deliberations, but only a recording of the meeting, according to Brennan. Jane has come to you, a solicitor, for advice. What advice would you give her?
Very good. Thank you. What do you think? So the first question I think that needs to be answered is, given the fact that the ANU doesn't appear to be a government agency, as it argued, does it mean that it is not covered by the Freedom of Information Act? I think that's the first question that we need to answer.
Well, wouldn't it have to be, do the Parliament don't really have a right to say you should give out all this information when they're a private agency?
Okay, so the basic question is, under the Freedom of Information Act, would institutions created by an enactment or a statute by the Parliament be covered by the Freedom of Information Act? So that's the basic question. Or is it only those that are agencies of the government, such as departments, agencies that really belong to the executive, as opposed to universities, for example, and some other institutions? It could be at some point the Australian Postal Office, had it been originally been created under an enactment, although it has not since been privatized. But it could be an institution created by an enactment of the government, or I mean by the federal government. Would it mean that it is no longer under the coverage of the Freedom of Information Act? That's the question. So, Monique, certainly this, under the facts, the ANU is created under an enactment. So the question is, would the Freedom of Information Act apply? So let's deal with that question first. From Peter, yes.
Andrew, sorry, I was going to ask a question. Does the fact that whoever wrote the report come into play, like, if that makes any sense?
It does, and we're going to get to that in a short while.
Okay.
But let's deal with that basic question first. Are institutions created by an enactment of the federal parliament covered by the Freedom of Information Act or not? Or are we just talking about agencies that clearly belong to the government? So what we need to understand is that under the Freedom of Information Act, it is not just government agencies that are covered by the Freedom of Information Act, but what are also known as prescribed authorities. And prescribed authorities under Section 4.1 of the Freedom of Information Act are those body corporates or even unincorporated bodies that have been established for a public purpose by or in accordance with an enactment of Parliament. So given the fact that the Australian National University is a body corporate that was created for a public purpose by an enactment, it is considered a prescribed authority and therefore covered by the Freedom of Information Act. So at least we know that there is a broader coverage of the Freedom of Information Act. It in fact covers institutions which we wouldn't think as ordinarily being part of the government. And that goes back to the question we had before, like, decisions made by universities, are they actually subject, for example, to judicial review? We had that question before, right? So for as long as a decision is made under an enactment, then in that particular case, it can still be subject to judicial review under the ADGR Act of 1975 Commonwealth. 1997 Commonwealth. Okay, so we're clear. We're now clear that ANU is subject to the Freedom of Information Act. The question is, she now wants to get a copy of the confidential report pertaining to sexual harassment, and she also wants minutes of the council deliberations, except that in this particular case, the minutes of the council deliberations are not in the form of written documents. They seem to be recordings. It's only an audio recording. So it's not a written document. The question is, is that report subject to the Freedom of Information Act, even if it was considered confidential by the ANU Council, which is the highest governing body of ANU, and pertaining to the deliberations of the council, not to release the report to the public, perhaps because it could have been embarrassing and so on, can the council be compelled to release documents relating to such deliberations? Okay, so from Courtney, embarrassment should not be considered. That's correct. Now, but the question though is, if somehow the council made a determination during its deliberations not to release the confidential report, or a report which to it was really confidential, can the council be compelled to release the minutes of the deliberations, of the council deliberations? That's the other question.
Surely, Manager, they would have to be able to be compelled to release the information. Otherwise, you could just classify every document as confidential and then no one would have any access to anything.
Okay. So very good. So the fact that a decision maker or a government agency or a prescribed authority makes a determination that it is confidential does not mean that it is no longer covered by the Freedom of Information Act. That's very good. That's correct. Now, assuming that that is so, does it mean therefore that the government that Jane, Anwar, or anyone can actually have access to the report? So there is a particular section for this, and that is section 47C, concerning public interest conditional exemptions, that it is actually open to the public to see copies of reports of scientific or technical experts. So because this is a report of scientific or technical experts pertaining to sexual harassment, then under section 47C of the Freedom of Information Act, it is not a conditionally exempt document. So that is not covered. So therefore, Jane Anwar actually has the right to access that particular document. Now, pertaining to the minutes of the council deliberations, what do you think? Is that subject to access with the public under the Freedom of Information Act? So assuming there is no transcript, so what you have is an audio recording. Is the audio recording considered a document? So let's deal with that first. Would an audio recording be considered a document under the Freedom of Information Act, so that if it has not been transcribed, it's just an audio recording? And assuming that had it been transcribed, it would have been available to the public under the Freedom of Information Act. Would it therefore now mean that if it is an audio recording, it cannot be the subject of the Freedom of Information Act? Let's deal with that first. Is it a requirement that it has to be a written document? So is it a requirement? The answer is no. So under section 4.1 of the Freedom of Information Act, a document under the act actually includes sound recordings. So just by, so a government agency or a prescribed authority cannot avoid being subjected to the Freedom of Information Act by not transcribing, any minutes of the meeting. Even if it were held in the form of a sound recording, under section 4.1 of the Freedom of Information Act, yes, a video, because it could be sounds, it could be images, or it could be writings. So it is a very expanded definition under section 4.1 of the Freedom of Information Act. It could be sounds, it could be images, it could be writings. So that would be covered under the Freedom of Information Act. Now, so the bigger question for us then is that, assuming that the audio recording is covered under the Freedom of Information Act as a document that could be the subject of access under the Act. The question is, would the audio recording of the Council deliberations concerning its decision not to release the report to the public also mean that the public can have access to the Council deliberations? That's the other question that we have. What do you think? So from Leonie, no. No, from Courtney. Very good. So that is the correct answer. The reason why is that if you examine Section 47C again of the Freedom of Information Act 1982 Commonwealth, particularly pertaining to public interest conditional exemptions, a document is actually deemed to be conditionally exempt if it involves a deliberative matter. So this is an example of a deliberative matter. So the reason for that is that, as we said, there is a balancing that the Act, that the Freedom of Information Act does, the need to balance the right of the public to have access to government documents as a way of making government officials publicly accountable, but at the same time, it would like to give an opportunity to decision makers to be able to make decisions and deliberate with frankness and candor in certain instances, without fear that whatever they say can end up potentially embarrassing them or potentially subjecting them to legal liability. So under Section 47C of the Freedom of Information Act, those documents that are of a deliberative nature are therefore considered conditionally exempt. And depending on the person who has control of that document, he can make a determination whether or not it is one that should not be released to the public, being one of a deliberative nature. Okay, so I guess those are my 5 discussion questions concerning the Freedom of Information Act. Would you have any questions about this topic or any other topic pertaining to administrative law? Because this is our final tutorial, and I thank you for joining me in 12 weeks of tutorial sessions, and for the very high level of engagement that you've shown, not only in the form of the during the tutorials, but also in the emails, but more importantly in our Facebook page. Do you happen to have any questions or comments? Yes. Obviously, the final exam is on Saturday. The final paper will be released on Friday. Thank you, Rob. Questions, comments?
Is it Saturday it's being released?
Yeah, it will be released on Saturday morning.
Okay, sorry.
Was it 9 o'clock that I said?
Yeah.
Okay, so it will be released on Saturday at 9 o'clock in the morning, and you have 24 hours, wasn't it?
Yeah.
To answer the take-home paper. Okay.
I had a quick question. I'm just doing some revision at the moment, and based on last week's revision tutorial, I remember you talking about one of the topics would be unreasonable decision making, and you referred to week. Now I can't think of the particular week, but I'm having trouble in my revision separating that topic from Wednesbury unreasonableness, and wondering whether I've misinterpreted the other topic and whether it should be unauthorised decision making, or am I right that it was unreasonable decision making?
Okay, so what we need to remember is that an action of the executive can actually be questioned on the basis of several grounds, and a lot of them are actually overlapping. So an example that you pointed out is decision making that appears to be unreasonable. Now, a decision that is unreasonable can be considered to impinge the rule against authorized decision making, because decisions can only be considered to be authorized if it is according to what is in the statute, for example. So that if it is not according to the statute, it can be unlawful because it is contrary to the statute, or it could be unreasonable in the sense that it doesn't, it can involve the exercise of discretion, which can then be considered unreasonable. So in that case, therefore, that particular instance can be attacked both as being an unauthorized decision, but at the same time, it can be the subject of the test to Wensbury and reasonableness. So those two clearly overlap. Although the idea about unauthorized decision making is actually a ground for judicial review on its own, such as when, in the case of Daniel versus Green, we will recall, regulations were made by the Director General that were contrary to the primary legislation. And in that case, the decision, therefore, that was made on the basis of the regulation that was contrary to the statute or the primary legislation would be an example of unauthorized decision-making. There could also be unauthorized decision-making, not because it is unreasonable, but simply because it is something that is not authorized by the statute. So, for example, and that again tells us that the instances when a decision may take into account irrelevant considerations, that is an instance when it could both be an instance when it would be unauthorized because there was the taking of irrelevant considerations, but at the same time, it is something that may not be permitted by a statute. So a lot of decisions can actually be attacked on the basis of multiple grounds because a lot of these grounds actually do overlap.
Thanks. So the topic of unauthorized decision making is more of an umbrella type of topic, which then has quite a few different ways of presenting itself. But there's also a separate ground.
Of which is Wensbury and reasonableness. But
yeah,
okay. But at the same time, if we follow the case of the Wensbury case, we will recall that the court in that case had pointed out that the idea of unreasonableness can actually be an umbrella term of its own as a ground for judicial review, separate from the issues of whether or not a decision was actually illogical, separate from the grounds of whether or not the decision was actually contrary to law. So that can be considered to be an umbrella ground for judicial review on its own, even if as it overlaps with certain other grounds for judicial review.
Thank you.
Thank you, Monique. Questions? So you are on the right track. So we're good. Okay. So I thank you for the opportunity to have guided you through your learning process in administrative law for the past 12 or 13 weeks. And I'm hoping that, having come out of this unit, you have learned a lot about administrative law, which is something that you can then take on with you as you become future lawyers and as you study other units in the laws program. And so I thank you for having very high level of engagement, which I didn't expect in administrative law. A lot of you have been joining the tutorials regularly. And I wish you well in the final take-home paper. And I ask that if you get a chance, please take the time to do the Have Your Say survey. And so with that, all the best, and I hope to see you again in one of our units in the laws program. Goodbye, everyone, and all the best. Bye.
Thanks, Manjo. Bye.
Thank you, Monique. Bye.